Assalamualaikum and hi, my name is Faradila. So for now, I'm going to explain the cases of Shahrizal.co versus Pendawaraya of the Cybersecurity, which is the first is facts of the cases. Okay, the facts of the cases is the appellant law firm, the 211 Shahrizal.co represented a client, Amma Ashrafi Zulkifli, who was investigated of offence under the Penal Code and Computer Crimes Act. Ammar facilitated unauthorized access to the immigration department system, which received illegal payments, and the public prosecutor under the Anti-Money Laundering, Anti-Terrorism, Financing and Proceed of Lawful Activities Act 2001, which is the seizes armed properties, including large sum of money and assets, considering them proceed unlawful activities. The appellant claimed sum of money from the seized asset as legal fees for the service rendered to Ammar, which is the High Court allowed the claim. The Court of Appeal reversed it in the appeal proceeded to the Federal Court. Alright, the next one is analysis and critique. Firstly, for the court reasoning that majority, no valid precedent, which is the High Court Iran interpreting an unwritten court of appeal decision Muhammad Shukri as binding. Precedent requires ratio dissenti, which cannot be inferred from unwritten rulings. Second is lack of legitimate legal interest. Simply producing bills and providing service rendered does not satisfy Section 614 requirements, and the property claim was proceed of crimes, not legal property that could be used fee payments, which is number 3 is cumulative condition not met. Section 614 require all 5 conditions A to E to be satisfied. The appellant failed to demonstrate this on abundant probabilities. Number 4 is Section 44 inapplicable. That section applies only during the freezing of property which before trial. It's not to forfeiture proceeding like those in Section 56 or claim under Section 61, which number 5 is constitutional right not violated. Right to consult, Art 523, does not imply the right to pay counsel which with illegal funds. Number 6 is no right to fees from illegal property, which allowing payments from such property would frustrate that legislative purpose of preventing criminal from benefiting from unlawful gains. And for the critique of the appellant's agreements, we can see that the firm relies on the Article 5.3 that misinterprets its scope, and it protects the right to legal representation, not the source of the legal fees. And it's also argument that denying fees will deter lower from accepting such cases for make it right. Illusory, lacks legal basis, access to the counsel doesn't simply guarantee payment from criminal proceeds. Then second, purposive versus literal interpretation, we can see that the court appeal correctly apply an purposive approach to Section 61 and consists with legislative intent. And comparative jurisprudence cases from the US, we can see that Calpin and Drydale versus United States and Singaporeans support the idea that legal fees cannot be paid from crime proceeds without implicit statutory authority. As the conclusion, the Federal Court unfurled the principle that proceeds of crimes must not be used to pay legal fees, and reinforcing the legislative aim for stripping criminal of illicit gains. This decision a strong affirmation is the integrity of forfeiture laws and a warning against relying on the unwritten judgment of making constitutional claims where none exist in law. That's all for the cases for today. Thank you.